the question which I am often asked, Mr. Nedumpara, why are you opposed to? I have written umpteen articles and speeches, in even videos, seeking for abolishment of Article 32 and Article 226. And I have said the Constitution, the founding fathers, though incorporated these provisions with all good intentions to make for the preservation of protection of fundamental rights, enforcement of fundamental rights. Today, these two articles act as a single impediment, single obstruction for the enforcement of, or for the obstruction for the common man in securing justice. Why? The reason I would say is Article 226 and Article 32 introduce a mechanism of justice delivery system which is absolutely discretionary. See, the fundamental principle of law, that the best law is the law which gives least discretion to the judge, and the best judge is a judge who exercises his least discretion. So discretion and justice are often not very compatible. And the 226 and Article 32 is primarily, it is undoubtedly and certainly in practice is a discretionary jurisdiction. So the access to the justice, access to these two provisions is entirely at the discretion or mercy of the judges, and that leads to arbitrariness, that leads to favoritism, that has led to denial of justice. And now, how come these two provisions came to be? The founding fathers, they were all many of them were very eminent judges, very eminent lawyers. And how these provisions came to be incorporated? I would say it is by more of an accident. Nobody ever thought tomorrow these provisions are going to create so much of a havoc. I say so in spite of the fact that sometimes these provisions are even today quite useful. I am not denying that. In England, there are two streams for administration of justice. One is ecclesiastical courts, other is common law courts, and the third is the equity courts. Then the common law courts, primarily it is a common pleas. The common law, the chief justice of common pleas. Common law court, the highest authority in those days, chief justice of the court of common pleas. So that is nothing to do with the claims of the state. Then the ecclesiastical court, that is, the church in those days, ecclesiastes means church. Church had a major role to play. Many of these issues in the realm of succession, all these issues were governed by the ecclesiastical courts. And after Henry VIII had a tiff with the Pope. So before that, all kings, the entire Europe was primarily under the supreme authority of the Pope. Roma locuta est, casa finita est. Rome has spoken, the case is closed. So the Pope was the spiritual, the ultimate spiritual and temporal authority. All kings were under him. But Henry VIII revolted against the Pope. And then then the relation between the Pope and the Vatican, or the Rome and the King, the England, it many ways deteriorated. In fact, there was a persecution of those who supported the Pope, the Catholics. And the equity court was primarily, equity court is where the king, chancery court. Chancery court is where how the chancery court came into existence. People agreed by the orders of the common law courts and ecclesiastical court used to go to the king. And king is being the ultimate founder of justice. So when too many cases came, the king had no time or patience to hear those matters. Then he enters the job to Chancellor. Chancellor was always a bishop. And the Chancellor, he was not much interested in law. He always asked the litigants, say, what is the actual grievance? And he looked at justice, equity and good conscience. So therefore, he was not about the technicality. He was more about the actual injustice cause. Then too many matters came. The Chancellor, then Vice Chancellor came to be appointed. Then the High Court came to establish. The Court of Appeal, House of Lords, the whole system came into existence. So this therefore, this has led to 2 or 3 streams of justice. Ecclesiastical courts, practically the after Henry VIII, the role of the ecclesiastical courts have been largely brought to an end by legislation and other means as well. Then primarily the 2 streams of justice, one is the common law courts and court of equity. And court of equity, the 2 streams of justice, the waters of these 2 streams run parallelly, but they never mix. So it led to a lot of difficulty. And therefore, in particularly reformists like Bentham, he asked for the abolition of these 2 system and synchronization, consolidation to one. And 1852, the Judicature Act was passed and said common law courts can also grant equitable remedies, and court of equity can also grant common law remedies. So then in 1872, 1873 Judicature Acts, Amendments Acts, both two streams of justice has been brought into one. But for India, the mutiny of 1857 led to the enactment of the Government of India Act of 1858. And the very next year, in 1859, CPC was incorporated. And 1861, the High Court Act came into existence. Then, for the Dominion of India, there is only one court. That is a court which can grant equitable and common law remedies. And therefore, the civil courts in India established by the British, they granted common law remedies and equitable remedies. But there is one exception. Before the High Courts came into existence, we had the Chartered Supreme Court established, which namely Supreme Court of Calcutta, Bombay, and Madras. These Supreme Court used to exercise the power of the King's Bench in England, used to issue prerogative writs. So therefore, after the 1861 enactment of the High Courts Act, the Chartered High Courts continued to exercise the writ jurisdiction. And the writ jurisdiction was quite popular. And therefore, when the Constitutional Assembly came into, when during the Constitutional Assembly, a demand was raised. Why not we extend this writ jurisdiction to all high courts? And nobody opposed it. The reason is, out of the anxiety, because during the British time, the personal liberties were largely being denied, and police atrocities, imprisonment, etc. So the whole concern was some or other in the independent India, fundamental rights, personal liberty should have the primacy. And therefore, Article 226 came to be established. And look at that. After Article 226 came into be established, then the High Court became, the writ jurisdiction became a major source of litigation of original side. High Court on original side. Look at the High Courts like Kerala High Court, Karnataka High Court, Madras High Court, most of the High Courts. The original jurisdiction of the High Court, writ jurisdiction is a major work. And here also in Bombay High Court also. Now the jurisdiction is, certiorari is a matter of right, but nobody will accept now. Mandamus also, it's in many ways it is, it's a matter of right. But today these jurisdictions are considered to be absolutely discretionary. With this jurisdiction became discretionary, then the concept of face value came. Then the perception is that only the kith and kin of judges, senior lawyers, the favored lord, they alone get justice. And now it is only more true with the Supreme Court. This Article 32 is unworkable. if Supreme Court, if the, say, nowhere in the world Supreme Court is a court of original jurisdiction, if Supreme Court is to function as a court of, really function as a court of original jurisdiction where everybody can approach it for enforcement of a fundamental rights, then we need a Supreme Court of 1,000 judges. And this is absolutely, the consequences of the Supreme Court being made a court of original jurisdiction, the consequence of the access to justice under Article 32 without recourse to any other court, I don't think was ever brought to the notice of the founding fathers. It was Article 32 is a well-intended provision which is unworkable. Thank you.